back to Legal Spirits, the podcast of the Mattone Center for Law and Religion at St. John's University. I'm Mark Movsesian. Today we're joined by Don and Lisa Drakeman to talk about a curious episode in the history of American constitutional law. How President Thomas Jefferson's 1802 letter to the Danbury Baptists, with its famous reference to a wall of separation between church and state, made its way into Supreme Court jurisprudence. Chief Justice Morrison Waite, with an assist from his neighbor, historian George Bancroft, rediscovered the letter and used it in the 1879 case of Reynolds versus United States, which is one of the Mormon polygamy cases. The court has backed away from that metaphor recently, but it has been and remains a powerful concept in U.S. law and politics. We'll talk about how Waite turned Jefferson's words into constitutional law, what this episode tells us about the risks of amateur history at the court, and how Jefferson's passion for French wine connects to the story. On this episode of Legal Spirits, Jefferson, Wine, and the Wall of Separation. Please stay tuned. Well, we're joined today by the husband and wife team of Don and Lisa Drakeman. Don is a distinguished research professor at Notre Dame's Center for Citizenship and Constitutional Government and the author of several important books on the Constitution. Lisa is a historian, a fellow at Cambridge University's Center for Health Leadership and Enterprise, and a certified sommelier with an expert-level diploma in wine. Don and Lisa, welcome to Legal Spirits, and I should say welcome back to Don, who's been on the podcast before.
Thanks, Mark. We really appreciate the chance to talk about our fun new article, and it's a real pleasure to join you today.
Always happy to be here, Mark. Thank you.
Thanks, Don, and Lisa, too. Okay, so let's talk about your recent essay in Law and Liberty about this curious story. So I think most of our listeners will be familiar with the wall of separation between church and state, and some may even know that the metaphor comes from a letter that President Thomas Jefferson wrote to a Baptist congregation in Danbury, Connecticut in 1802. And in that letter, and he's referring to the religion clauses of the First Amendment, Jefferson wrote as follows. I'm just going to quote it. Believing with you that religion is a matter which lies solely between man and his God, that he owes account to none other for his faith or his worship, that the legitimate powers of government reach actions only and not opinions, I contemplate with sovereign reverence that act of the whole American people which declared that their legislature should make no law respecting an establishment of religion or prohibiting the free exercise thereof, thus building a wall of separation between church and state. Well, that letter and phrase would probably be forgotten today, if not for a man named Morrison Waite. Now, unlike Thomas Jefferson, Morrison Waite is not exactly a familiar name, even for those who follow Supreme Court history. So who was Morrison Waite, and how does he figure in this story?
Waite was a Yale graduate and a really largely unknown Ohio lawyer. His primary qualification to be Chief Justice was exactly that obscurity. He was what we would call now a stealth nominee from a swing state. Behind his back, other members of the court who had hoped to become Chief Justice referred to Waite not as his honor, but as his accidency. Waite's biographer says that the Chief Justice was so concerned about constitutional cases that he occasionally shifted his votes so that he could control the assignment of the opinion in an important constitutional, especially case of first impression. That's exactly what happened in Reynolds. He took the opportunity to talk generally about the religion clauses, even though the wall of separation and the establishment clause that it's been connected to really wasn't important in this case on Mormon polygamy.
So I should say, by the way, listeners, that Reynolds is one of the cases that we cover in our Mattone Center YouTube video series, Landmark Cases in Religious Freedom. So I just want to make a plug for that, and I want to encourage everybody to listen after you finish listening to this podcast. Go and check that out. Okay, so Reynolds is a case involving Mormon polygamy in which an LDS church member claims that he has a constitutional right to engage in polygamy because that's a religious conviction of his. And Waite writes this opinion. And by the way, I didn't realize, so he may have been unknown, but he was certainly crafty based on what you're saying. He writes an opinion, and it's a unanimous opinion, that the free exercise clause does not confer a right to practice polygamy, even if one's religion commands it. And he relies here on the belief and conduct distinction that comes through in Jefferson's letter. You know, the state cannot regulate belief, but it can regulate conduct. And crucially, Waite grounds that in Jefferson's letter that I read before. Actually, Waite quotes from the letter in the Reynolds opinion. And that's curious because, as you say in your essay, that letter from Jefferson had largely disappeared from public memory, if in fact it ever had been noticed by the public. It was written to a private congregation in Connecticut. So how does Waite discover this letter?
The Chief Justice was not sure what the religion clauses meant, so he reached out to his friend George Bancroft, who was at the time the most famous historian in America. Bancroft pointed to Jefferson, but did not explain why Jefferson held the key to the religion clauses. So Waite dug into Jefferson's recently published collected works. The index directed Waite to the now famous 1802 letter.
Okay, so if I understand correctly, so Waite has help from this. And by the way, I had heard of George Bancroft. I'm not a historian. Both of you are historians. I did hear this name. I guess he was pretty famous at the time. And so he helps Waite. He suggests, Waite go take a look for this kind of thing. And Waite finds it. I didn't realize he used the index. That's sort of interesting. And so he then uses this letter to explain the meaning of the First Amendment, of the religion clauses. But here there's a bit of a problem, right? Because Jefferson, he certainly had a role in cementing religious freedom in the United States. He drafted a very important statute historically. I actually teach this in my law and religion seminar, the Virginia Statute on Religious Freedom in the 1780s sometime. I'm not sure, 1786, I'm not sure what year it was. He was very proud of that. Jefferson even asked for that to be included on his tombstone. So he is someone who had some impact here. But when it comes to the U.S. Constitution, Jefferson wasn't even in the country at the time that the Constitution was adopted. And there's also no indication that maybe you can tell me, I don't think there's any indication that he was involved in drafting the First Amendment a year or so later in 1789. So when we say that Jefferson should inform the understanding of the religion clauses, you have to get past the difficulty, which is that Jefferson really didn't have much to do with the religion clauses. So how did Waite get around that problem?
It's all because Jefferson was in the wine business. Waite delved further into Jefferson's works, and he found a lengthy correspondence between Jefferson and Alexander Donald, who was a Virginia wine importer. Jefferson was advising him on the best French wines and arranging for the wine shipments. In one 1788 letter, for example, Jefferson alerted Donald to an upcoming shipment of Chateau Margaux 1784, which he called the best vintage in 9 years. But a second 1788 letter to Donald would end up building the wall of separation between church and state. Commenting on the process of ratifying the Constitution, Jefferson wrote, "I wish with all my soul that the 9 first conventions may accept the new Constitution, because this will secure to us the good it contains." Nevertheless, Jefferson hoped for a few amendments, saying, "I equally wish that the 4 latest conventions may refuse till a declarations of rights be annexed, which shall stipulate freedom of religion, freedom of the press, and so on." This is the only link Waite found between Jefferson and the adoption of the First Amendment. But Waite decided it was enough to call Jefferson an acknowledged leader of the advocates of the religion clauses. And therefore, Jefferson's letter about the wall of separation would become, as he put it, almost an authoritative declaration of the scope and effect of the amendment.
I just want to make clear I understand this. So this person Jefferson is writing to, I mean, I'd never heard of him. I don't know if anyone has ever heard. He's just a guy in Virginia. I mean, is he a famous person? Does he have some role in any of this?
His primary role was to help Jefferson acquire and deliver wines to Virginia. So he was a businessman.
And that's it. It's just a business contact. Jefferson is writing him because he's going to be importing wine for Jefferson, or
Yeah.
Jefferson is
And,
just trying to give him what's the story?
and they have a relationship where Jefferson's making recommendations to him as well.
I see. They have a business relationship about wine, and that's it. Otherwise, this person, is not anybody anyone has heard of. He wasn't involved in the ratifying debates. He wasn't a famous writer. He wasn't anything like that.
None of those things. He was just the wine dealer to the first families of Virginia, and
I see. Okay.
so he wanted to get the good stuff. Jefferson found it and shipped it over to him.
Okay, so I guess look, history often turns on these accidents, and this is an example of that. And as you say, if I could just recap this for the listeners, so to show the relevance of Jefferson's understanding of the First Amendment, of the religion clauses, that is the wall that they create a wall of separation between church and state. Morrison Waite, who is the Chief Justice, relies on basically an offhand remark by Jefferson in favor of amending the Constitution to expressly protect religious freedom in correspondence, which was about an entirely different subject, French wine. Okay, and that's the basis for saying that the First Amendment, which was adopted, I guess, a couple of years after this letter, this correspondence, is properly understood to reflect Jefferson's views about what the First Amendment means, namely that it erects the wall of separation. That's what I understand from your essay and what you've just said. And so as trained historians, you are very critical of this, of what Waite did here. In fact, in your essay, you say this is, quote, stunningly flimsy. So what's the problem here? As I say, history often turns on these kinds of accidents. So what's the problem with this?
Well, Mark, I guess you could say that his accidency found a very convenient historical accident, and he ran with it. So we know that Jefferson was in favor of religious liberty, as you pointed out, but he was in favor of it across the Atlantic and not around when the religion clauses were being drafted. How would then Jefferson count as an acknowledged leader of the proponents of the religion clauses themselves? That would have been hard to do from several thousand miles away, even if he'd tried, which he didn't. A letter to his wine broker would seem to be a good example of flimsy evidence. And even if he were a leader of the First Amendment advocates, why focus on a letter to a small group of Connecticut Baptists that was written a decade after the Constitution was drafted and ratified?
Don, could I ask maybe, how about this letter to the Baptists? We're focusing so much on this correspondence with the wine merchant, but do we know, and I don't know the answer to this, do we know why Jefferson wrote that letter? Was he responding to something? Did he just decide to write to the Baptists of his own? I mean, I understand Thomas Jefferson had a lot of time on his hands. He was going through the Bible and cutting out passages. So, maybe he just thought he'd write to these people. But what was the occasion for that letter?
The actual occasion was the Baptists had written to him to complain about a day of prayer and fasting and thanksgiving declared by the government in Massachusetts, Connecticut. The New England governments had been doing all the way back to the Puritans. And they didn't want Jefferson to do the same thing as George Washington had done when he was president and John Adams had done when he was president. And Jefferson was writing back saying, nope, I'm not going to do it. And I think that the, wall of separation is between church and state. And that was it. It was unheard of by anybody till it appeared here, and then unheard of by anybody until Justice Black in the 20th century, in the Everson landmark school busing case that talked about the Establishment Clause, quoted Justice Waite quoting Jefferson, and all of a sudden, that's the authoritative gloss on the Establishment Clause. If you want to learn more about the letter, why he wrote it, what the early drafts of that letter to the Baptists look like, Daniel Dreisbach from American University has written a terrific book. So look for Thomas Jefferson and the Wall of Separation.
Yeah, I'll do it. By the way, I should tell our listeners we also have a video on the Everson case, and I encourage them to go look at the video about the Everson case too. But Don, as you're talking, I mean, it sounds to me like this is I'm sure Jefferson believed this in the Wall of Separation, but also Jefferson was a political figure, and political figures love to write to constituents and say, I agree with you. You really got this right, and it's kind of a flattering thing, right? I mean, this is kind of a political letter that Jefferson is writing.
It was indeed, and you can see how some of the New Englanders in his administration tried to sort of mild it up, as it were, in case it did get out, because this kind of separation talk was not very well thought of. And you'll recall that Jefferson was accused of being an atheist when he was running for president. So it's a bit of a hotter issue for completely different reasons than we think of it today.
That's interesting too. So I want to go find this thing by Dan Dreisbach. That's interesting that you can see how his administration was telling him to dial it back a little bit.
Exactly.
That's also interesting how that also never changes apparently in U.S. politics. That's interesting too. Okay, so that's why you think it's a flimsy thing, because after all, Jefferson wasn't here. Also, just one last other question on this. And I guess Waite never gave anyone a chance to respond to this, right? I mean, he just puts it in the opinion. It wasn't like he went to anyone else and said, do you think this is a good idea? Do you know, is this a fair representation of the framers, or no, he just put it in. That's it.
Exactly right. And nobody talked about that aspect of the case. If you look in the 19th century to see what people would quote from the Reynolds opinion, it wasn't that. He was quoted somewhat routinely by state courts in the part in which he said that we don't give exemptions for religious purposes, that that would make every man a law unto himself, as Waite.
Right.
That was a popular line from this. And the whole thing would have disappeared completely if Justice Black hadn't picked it up in the Everson case.
Very interesting. Okay, so I think it's worth underscoring, though, that even though, okay, this wasn't famous at the time, Justice Black kind of revived it when it had been forgotten, I think it's worth underscoring that the metaphor of the wall of separation between church and state, which comes from this letter from Jefferson, has had enormous influence, both in the court's decisions and also, I think, on public perceptions of church-state relationships. I mean, even though the court has stepped back from this metaphor in some recent cases, you both write that constitutional history would have looked very different if Waite hadn't focused on Jefferson in the way he did. And that leads to another question, which is, okay, we all know the court today is focused on history and tradition. That's their new test, history and tradition in interpreting the meaning of the religion clauses. So what lessons do you think that justices today should draw from this episode with Chief Justice Waite about the dangers of using history this way?
There's a lot riding on these church-state cases, as you know, Mark. These are hot issues in the public sphere. And we're only human. We tend to like whatever version of the history supports what we think is the right way to do it. As a result, what we've seen in a lot of discussions everywhere from backyard debates to the Supreme Court is flimsy history. People find a text, whether it's the wall of separation or something else, and they just stick with it. And I think if you want to ask the historian in me what would be a better thing to do, I'd say let's ask the people who actually did frame the amendment what they thought they were doing. And we, in fact, know that. It was published in the newspapers. It was a debate featuring James Madison and other people who introduced the language into the First Amendment. And this is what Madison said, and the other people who submitted other language said, we agree that's what we're doing. We just like our language better. And they said that the goal was to ensure that Congress should not establish a religion and enforce the legal observation of it by law, nor compel men to worship God contrary to their conscience. That's it. No wall of separation, just no national church, and no forcing people to worship other than what they believed in their own hearts and minds. So,
Okay, well, actually, I'm sorry, Don, but now you've opened up a big can of worms because if I hear you correctly, and we don't have time for this in this episode, listeners, but if I hear you correctly, you are saying actually there's not a general right, there's not a constitutional right to a religious exemption for conduct outside of worship. It sounds to me what you're saying is, okay, it's about worship and liturgy and prayer, but it's not a general sort of thing. Am I getting you right?
what I would say is let's talk soon about my new book on the free exercise clause.
Okay, that's a deal. We'll come back and talk about that because that, I mean, so listeners know that is a big debate, and actually, I don't want to just let that go by without at least acknowledging you've stated something which, at the very least, is a controversial subject in church-state law. So we'll have to come back and talk about that too. But I take your point. I mean, this kind of history is this we often hear of called law office history? Is that what's involved here? That it's just a forensic thing. You got to reach a conclusion, and so you pick up what you can to reach that conclusion.
Yes, as a matter of fact, and he didn't have to say the wall of separation to resolve this case. He didn't have to quote that letter. Waite was really trying to do the right thing, and you have to give him credit. He went to probably the Library of Congress himself. They didn't have clerks back in the day, and he found this letter. And it was, since you liked the point about the index, under a heading called "Religion Must Be Free." So, but not free all the time, such as in this case.
Yeah, I mean, look, good for him. Yeah, I guess he went to the Library of Congress. He probably walked across. Well, no, the court wasn't there at the time, so I guess he may have to take a trip to get to the Library of Congress too. Anyway, good for him. So listen, before we wrap up, let's talk a little bit about Jefferson and wine. So Jefferson was a passionate wine, and that's central to this story, right? So Jefferson was a passionate wine drinker and collector. I heard somewhere he had a glass of wine every evening, although apparently the glasses were a lot smaller in those days than they are today. So he wasn't drinking a lot, but he was drinking often. So let me ask you, what wines did he particularly enjoy? And if listeners want to go celebrate the First Amendment, can listeners still find those wines today?
Well, that's one of the wonderful things about this famous region, Bordeaux. It endures and in many ways is unchanged in terms of the wines that are available. Chateau Margaux, one of the famous first growths, considered one of the top handful of wines in Bordeaux, was very high on his list. That's the wine Jefferson sent to his partner, Alexander Donald, in 1788. But at about $600 a bottle for the 2021 vintage, which won't be ready to drink for at least a decade or two, that might be pricey for your listeners. A somewhat more affordable, maybe about $70 wine from the same Bordeaux neighborhood is Seigle. It's an earlier drinking second wine. That means it's not the most famous wine from the domain, it's the second one, but it's the famous Chateau Rosan Seigle, which was founded in the 17th century. Jefferson spoke highly of this historic wine producer, enigmatically telling Donald that if he were to visit Madame Rosan, mentioning Jefferson's name would be helpful. For listeners interested in white wines, Jefferson cited Chateau Carbonieux, a Sauvignon Blanc based wine, as one of Bordeaux's best, and that's still true today. It's a blend that incorporates Semillon, which, along with some aging in oak, softens the aroma and the feel of the wine in your mouth. La Croix de Carbonieux at about $25, or Chateau Carbonieux Blanc at about $50 are also both great choices. So we can enjoy the wines that Jefferson did, made in the same locations in a very similar manner to the 18th century.
And can I ask you, Lisa, so did Jefferson, I guess I gather from what you're saying, Jefferson knew what he was talking about, right? That he actually did know something about wine. This wasn't like amateur history from Chief Justice Waite. This person actually knew something.
Oh, I think Jefferson was devoted to wine and had extensive wine knowledge. You can read volumes about his collection and his interest in wine. So there's no question that he would have been one of the acknowledged experts in the U.S. on French wine.
Well, okay, he was a man of parts. So I mean that's another part of the Jefferson legend, I mean just one of the smartest people ever to be president, one of the most well-read, one of the most sophisticated people ever, even if I'm not sure I agree with his interpretation of the First Amendment, but I mean, let's give him credit where credit is due. Well, Lisa and Don, I think we'll leave it there. So thank you so much for joining us on this episode.
Thanks so much for having us, Mark. It was really fun and a pleasure.
I really enjoyed it as well. Thanks, Mark.
Great. Well, listeners, I want to tell you, make sure to read the Drakeman's essay, which is called The Wine Key to the Constitution. It's on the Law and Liberty website. And thank you for tuning in to Legal Spirits. You can find past episodes on our website and on all major podcast platforms. Please subscribe so you can receive notifications as new episodes become available, and also check out our YouTube channel for more resources on law and religion. Until next time, I'm Mark Movsesian. Thanks for listening.